Good morning, everyone. The first case to come before the court is State of Ohio Village of Lodi versus Blankenship, and each side will have 15 minutes to present their arguments, and you will have 5 minutes to reserve if you so choose.
Thank you, Your Honor.
Just let me know.
Yes, Your Honor, I would like to reserve 5 minutes for rebuttal time.
Thank you.
May it please the court, counsel. My name is J.R. Russell, and I am here representing the State of Ohio in this appeal. This is a case where the trial court made a legal error in determining that a citation for OVI was defective for failure to list the date, time, place of the offense, and failed to circle on the citation operator. This court should decide this matter on a de novo review. 5th District confirmed this, 4th District in other cases, that such legal errors should be decided without any deference to how the trial court decided the matter, meaning not under abuse of discretion, but the court's free to substitute its own judgment for that of the trial court. We respectfully submit that this honorable court could decide this case in 3 different ways, and we submit that those 3 ways would all be in favor of the state by sustaining one of the assignments of error. One, this court could reverse the finding that the citation was defective and instruct the trial court to proceed and find the defendant guilty based on the facts that were contained in the record that were sufficient to establish an offense. Secondly, this court could reverse the finding that the citation was defective and instruct the trial court to proceed with the arraignment. Finally, in the alternative, this court could determine that the proffered plea of no contest was not properly accepted, and for that reason, double jeopardy did not attach. Remand this matter to the trial court to proceed on the second case based on the same facts as the first offense. It cannot be disputed under the applicable law that the date and time of the offense on which it occurred is not an essential element of this particular charge. I believe the Williams court supports that supports that proposition. McFeely, some of the others cited in the briefs, that a ticket is not defective for OVI simply because it fails to state the date and time that the alleged offense occurred. In this case, there was some mention in the record that the citation failed to indicate the place that the offense occurred. I would agree that if the citation didn't indicate that the offense took place in the village of Lodi or the state of Ohio, that would be a jurisdictional defect that would cause reason to dismiss, but that's simply not the case. If you look at the citation, in several places it indicates that this offense occurred in Medina County, state of Ohio, village of Lodi, and in fact indicates the place, the streets where that offense allegedly occurred in this matter.
Well, I'm a little confused though in regard to what the complaint said about driving.
Well, 2 things. One, the Supreme Court has said to state an offense, a ticket prepared in accordance with Traffic Rule 3 simply needs to advise the defendant of the offense with which she is charged in a manner that a person who was making a reasonable effort could understand the complaint. Also in that case, the O'Connor case is what I'm referring to, the court indicated that simply putting DWI or OVI with the applicable code section was sufficient to allege an offense. And in that case, the defendant here has entered a plea of no contest or proffered a plea of no contest, wasn't challenging the facts that alleged, and by simply citing the OVI and listing the applicable case numbers, it puts a defendant on reasonable notice that under the statute, the defendant is charged with operating a motor vehicle either under the influence of alcohol or, secondly, under a prohibited concentration of alcohol as determined by the test. So well, by that provision alone...
Yeah, I'm sorry, but the reason why I'm asking that is the because your main argument is, well, you have several arguments, but pertaining to your one argument, especially in regard to the double jeopardy, that either the court didn't accept the no contest plea, that's one argument, but the other argument is that I think you have to make this argument, either they didn't accept the no contest plea or that the court didn't find them not guilty. In other words, the court seemed to be indicating in its journal entry that it couldn't find her guilty because there was no charge that was alleged.
Yes, that's my reading of it, Your Honor, and I think that that's the thrust of the trial court's legal error. This judge is a very good judge in this case, but everyone makes mistakes, and this was the legal mistake that this particular judge made. In addition to just the OVI in itself stating the offense in the citation, all of the other facts, even if you just go by the citation itself, support a finding that the defendant operated the motor vehicle, notwithstanding not circling the operated, by means of...
Let me stop you there. I'm assuming that this is a form of some type.
Yes, Your Honor.
Well, so the form in the part that it has operated has passenger and some other language that aren't even verbs. So what are we to make of that?
Well, I agree, Your Honor. The passage you're referring to says operated, passenger, parked, walked. And again, with the other facts that are listed, those other things have to be ruled out. As passenger is a noun.
Why would they be on there? How do you walk a DUI?
Exactly. And
park a DUI.
The reason is because the uniform citation is meant to be a catch-all for several different types of offenses. And operating a motor vehicle under the influence of alcohol is a strange citation in that it is very much both a creature of criminal law and of traffic law. But the citation is designed that an officer could issue a parking ticket or perhaps a jaywalking citation. But again, when you list the facts that are listed here, the 1994 Chevy Beretta, the license plate number, the officer wrote the operator license number, all of these facts indicate that passenger, parked, walked is not applicable. And the type of vehicle is listed. Maybe we would be dealing with a different case if they didn't have the vehicle listed or any of the other facts that were contained therein, but that's not the situation. It's simply, in this particular case, having to circle the operated is inconsequential because all of the facts indicate that those other items listed in the uniform traffic citation, even putting away for a second what the Supreme Court decided in the O'Connor case, simply do not apply in this case and could not apply, and there could be no confusion to the defendant of what she was actually charged with in this matter. Then you look to, also contained in the record, was the form provided for the administrative license suspension. I believe the trial court, if it had accepted her plea of no contest and was allowed to look into the facts of the record, which I believe the court is, that form provided all of the necessary facts, date, time, place, the results of the chemical test, the fact that the defendant operated the motor vehicle, which again, just by way of doing OVI and the code sections would be sufficient.
And did that have the appellant's signature on it? The notice?
I'm sorry?
The ALS notice.
Yes, sir. The officer signed the ALS notice.
Did the appellant sign the ALS notice?
I don't recall. I know that the defendant signed the citation, but I don't have that part of the record here in front of me to say, and I apologize, I cannot recall. one of the defendant's main arguments in this case is that the Ford and Walt decision and the statute would prevent the court from reversing the decision from the trial court. One, I tend to agree more with Judge Whitmore's dissent in the Ford and Walt decision, particularly that where she says that the requirements of the statute are met when there is evidence in the record to support each element of the offense, which is true in this case and what's happened in this case. But putting that aside for a moment, I don't believe the Ford and Walt decision applies in this case, because the Ford and Walt decision dealt with a defendant who had been found guilty, and the defendant in that case alleged that the trial court, even if the record was sufficient to establish the charge, didn't adequately advise the defendant of that. And for that case, I believe it's essentially a red herring in this matter and does not apply. Ford and Walt itself discusses that the case was limited to the fact that the defendant was found guilty.
And counsel, you're into your rebuttal time.
It simply doesn't apply to that.
It's up to you whether you want to proceed or whether you want to save your rebuttal time.
And again, just with the double jeopardy argument, we submit that the plea of no contest wasn't accepted. If you look at the colloquy that the judge gave, it was clear he even indicated, I'm dismissing this case, the state is free to refile, which indicates to me that double jeopardy did not attach. Thank you.
Morning, Your Honors. I'm Eric Hedrick. I'm here for Ms. Blankenship. First, if I may, this is a copy of the complaint. Yes. The original. Yeah, okay. Your Honors, may I approach? I just want to
And this is obviously in the record?
This is in the record. I ripped it out of the copy I made of the record. This is the original complaint that I would just allow the court to look at as we're discussing this matter. But the elephant in the room that the state is trying to get away from is the fact that there is absolutely no indication of the actus reus that was engaged in by the defendant in this case, and that just simply can't be gotten around. There's no way to fill that gap or to plug that hole at this point. And that isn't very much what the trial court...
But to take your argument to the logical conclusion then, if it didn't charge an offense, doesn't it just go into the city's argument or the state's argument that then you have the right to dismiss and refile?
Well, yes and no. The state doesn't have the right to dismiss or refile, and in fact, the state's not even present at this proceeding. This is happening in all municipal courts operate in different ways, and in this particular municipal court, the state's not present. That's the state's choice. The state was not there to ask for an amendment. The state didn't. But what happened was this was submitted for arraignment. The court gave the defendant the option to plead no contest, and the defendant elected to do so. At that point, 293707 is invoked, and this district, this very court, citing the Ohio Supreme Court, has explained very clearly, very concisely, that once a defendant pleads no contest, the defendant has a substantive right at that point to a finding of guilt or not. And so...
But what if the court doesn't give a finding? We understand that the defendant has the right because if you plead no contest, but if the court says, I'm not accepting the plea.
Well, and that is very important that we get into that, what the court in fact did, because At the time, there was no one there for the defendant or for the state to point out or remind the court, here's the actual process that you must engage in now that no contest has been offered. But what the court does is get there in a roundabout way. The court says, this is deficient, I can't make a finding of guilt. The court used the word dismissal, but by the time we get to this double jeopardy hearing, the court points out, this is a deficiency, and I'm going to find that, and I do in fact find that I accepted her guilty plea, and that Miss Blankenship is indeed, her guilty plea was accepted, and I found her not guilty because of the deficiency.
That's what the court said during the double jeopardy.
Right, and if I may approach again, this is the judgment entry from the second case number. So, Your Honor, if I may approach, this is the entry that the court put on following the double jeopardy hearing.
Thank you.
Yes. And the court says that it accepted the no contest plea.
What do we do with that, considering the fact that the court at the oral hearing, according to the transcript pages that I think you both said, that it said, I'm not accepting your plea?
You're talking about the original arraignment? Well, I don't believe the court said it did. I don't want to use the wrong language. Because the only, and this actually brings up an important point. I don't think that the court actually says, yeah, he says I'm dismissing the case. He doesn't use the word.
And they can refile it.
Right, he does say that, but he doesn't say I won't accept your plea.
But if you accepted a plea, why would you say I'm dismissing and they can refile it? That's
the way I see it is
inconsistent.
Right. Well, exactly. But you can refile it as not a holding or a finding. That's just kind of an off-the-cuff statement following what he's doing. But I think what's really going on here is the court isn't necessarily cognizant of 29-3707. At least it's not immediately at the forefront of the court's attention at the time that this is all taking place. So the court's, and it's sort of counterintuitive to think I'm accepting a no contest plea, not guilty. It's just sort of counterintuitive for a municipal court to engage in. But what has happened here is what I've just given the court. That entry is the court's last finding about what it in fact did at that original hearing.
But if according to the transcript that the section of transcript that you cited in your brief,
yes,
where it says you still wish to plead no contest to the charge of operating a vehicle, yes. Well, actually, the ticket's defective. On further review, the officer never put a date, time. He never said that. He never said I'm accepting your plea or not. He like tossed it before he even addressed whether or not she was there.
Well, he asked her several times, do you wish to?
Yeah, and she kept saying yes, 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 but he never said, okay, I'm accepting your plea and I'm making a finding of whatever. He never said.
Right. And what I'm saying is, the court essentially did what the process that it is supposed to engage in under 29-3707. It actually did that. It said deficient, and what deficient means is, if all the facts aren't there, you have to enter a finding of not guilty. And that substantive right did in fact kick in at that point when she tendered that plea. And then that entry that I put in front of you, the court actually says, and courts do this all the time, they look back at their hearing and say, oh, I didn't journalize this properly, this is actually what I did. Essentially right now, if this court would allow it, I could move this court to give jurisdiction back to the trial court, and it could actually submit a non-pro-tunc entry and just check, that we found that she did in fact enter the no contest plea, and that I accepted it as the court, and that's what he's done right there.
Accepting a non-pro-tunc can't change what happened. It's to reflect what actually did happen because there was an error. And I guess the reason I'm pointing that out is because, yes, the court does say, court accepted no contest plea, I'm not even sure what that means when it says the court accepts a no contest plea. Because the court, like you said, has a duty to say either guilty or not guilty. We all three were municipal judges and took many no contest pleas. And you do have to find it's knowingly, intelligently, voluntarily entered, and find you guilty or not guilty based on, waiver of the recitation of facts, based on, whatever. But the point is, the court never got to that point, at least in the written transcript portion. And so, I don't know what you do with that.
And especially, just to tie into your thing, he's got motion to dismiss granted, court accepts a no contest plea. Those things are like...
Not court accepts it, the court accepted it. He's speaking about what he did in the
They
past.
accepted no contest plea, but somebody made a motion to dismiss.
Right, so these are two case numbers. The state refiled a complaint, and then the defendant filed a motion to dismiss based on double jeopardy. So at that point, the argument and the discussion is, was that original plea, was it accepted by the court? So the court's just summing up the fact that, yes, I did, whether it came very clearly through or not, that was my intention. This is the rare circumstance, the odd circumstance of, there's nothing else going on to glean from the record, it's just coming out of the court's head. Did I accept that plea or not? And the court's saying, conclusively, yes, I did. I did accept that plea, and it was the court's decision. And I mean, all we're talking about here is whether or not that court checked that I accepted the plea box as it's flying through those arraignments, and that box is in fact left off.
Counsel, I'm just not sure I guess just because I was a municipal judge, when you say they're flying through the arraignments and they just check a box, you have to make an actual finding. I hereby accept your plea and find you guilty. Well, and that's what I'm just trying to get you to address specifically.
Right, and maybe I'm not articulating it the right way. I think what I'm saying is the court really, even though it didn't use the proper terminology, because it's kind of a strange circumstance under that section, it essentially got from A to B anyway, because the court can't dismiss that at that point. When the court allows the tender of the no contest plea, that defendant has a substantive right to one of the two findings, guilty or not guilty. And the court...
So you're saying the court, I see what you're saying, you're saying the court didn't have an option of just dismissing, so you're equating the dismissal to a not guilty.
Precisely. I think that's really what the court was getting, because the court said, look, I'm finding it deficient, and there's nothing else left to do but say, and thereby, you're not guilty. And then, and again, I guess I keep trying to make the analogy, maybe it's not useful, so I hope I'm not beating a dead horse, but I think when the court says, when it has its last word about, I accepted the plea, that's as good as anything that the court could do. I mean, the court could have just said, I did accept your plea in that hearing, and it could have said, here's another pro-tunc entry, I just forgot to check the box the first time. But the court is saying, clearly, I did accept her plea. If it didn't come through in my entry the first time, it's coming through now. And that's what's happened here. Because essentially the court does exactly what 293707 calls for. It looks at the facts alleged and says, you don't have a case, state. So, Ms. Blankenship, she, without an attorney's assistance, offered that no contest plea and gave up her rights. At that point, she was entitled to the finding, and the court actually made the finding. It just didn't actually use the words that it needed to, or that we would expect to hear from it, but it eventually got there upon reflection, and the court made its voice heard in that entry. Are there any other questions from the court this time?
Apparently not. Thank you so much for your answer.
Thank you, Your Honors.
Thank you. You still have about 3.5 minutes.
Thank you, Your Honor. I would note that I believe the court, just because a plea is offered, a trial court does have the option to not accept the plea. I'm sure that the three of you did that at some point, where you didn't believe that someone was knowingly, voluntarily, intelligently submitting the plea. So just because a plea is proffered, the trial court has the option not to accept it. When counsel says that he conclusively, the trial judge conclusively in the last entry reflected what happened, I don't believe that's the case at all. If you look at the statements on the record that was made at the motion to dismiss hearing, at first the judge can't recall if he actually was the one presiding over the arraignment. And he says, well, my recollection is basically the trial court was doing this off of memory without the benefit of the transcript. He says that there was no date, no time, which again is not an essential element of the offense. No place, nothing marked at the top. That's just not true. There was the place. There were things marked at the top. The nunc pro tuctentry, as you point out, if it were reflecting what actually happened, he says, yeah, but he never put any of that down. Therefore, a no contest plea. I'm dismissing the case because of the defective ticket. Now, he could refile it, but at this point, I'm dismissing it because the ticket is defective. Again, we submit the ticket was not defective, but I think that clearly shows that the trial court was not accepting the plea and was intending to dismiss it and allow the state an opportunity to refile. The defendant.
Well, I think you would agree that the court really did engage in some contradictory and inconsistent statements.
And again, you know, the trial court is doing this the second time without the benefit of the transcript, trying to piece together what actually happened. And so that was a difficult position for the trial court to be in. An understandable error, but an error nonetheless. The defendant never moved to dismiss this ticket. And I don't believe, again, that 2907 is relevant to this. The trial court wasn't cognizant of it at the time because the trial court was not making a finding of guilt. The trial court was dismissing the citation. This court has said the required explanation of the circumstances would be included in a statement of facts which support all the essential elements of the offense, which again, based on the record, the trial court clearly could have done. The trial court did not, per se, comply with the statute because a trial court needs to comply with the statute when there's a finding of guilt. The trial court needs to advise the defendant of the explanation of the circumstances that support the finding of guilt, but a finding of guilt wasn't made.
But the appellee raises a good point in the respect that all the way through he's accepting the plea. He's not indicating that he's not going to accept the plea. Do you still want to plead guilty? I mean, no contest is the last thing. Do you still want to plead no contest, or are you under the influence of alcohol or drugs or blah, blah, blah? Then, yes, still want to plead no contest. And it's like he looks down at the ticket and says, oh, it's defective. So it almost is like he's finding her not guilty, isn't it? Because he's saying, you know, all the way through, he's getting ready to accept this plea, you know, no contest. And now I can't really find you guilty.
Well, I think the trial court goes through the series of questions, and just because, you know, a next question is asked, it just means that he's proceeding to the next question. Because, as the three of you know, the trial court has to go through a series of questions to make sure that the plea is knowingly and voluntarily.
But you usually say then, too, I'm sorry, I can't accept your plea.
Or the court would say, I'm accepting your plea and I'm finding not guilty because of the facts alleged in the citation do not support the essential elements of an offense. But when the court says, now he could refile it, but at this point I'm dismissing it. I think it's fairly clear from the statements of the trial court that the trial court was not accepting the plea. But if he had, we submit that the citation submits the essential elements of the offense. The Supreme Court has said you have to cite the statute, OVI is sufficient, and citing the statute, that's sufficient to put a defendant on notice.
And your time is up.
Thank you.
Thank you so much. Thank you very much, both of you, for presenting your arguments to the court. The court will take the matter under advisement and send you a written opinion, and you can also check on the court's website. Thank you.
Thank you, Your Honors.
Thank you.